Good evening. Welcome this blessed Tuesday on another day on our program, The Law and You. We had a wonderful, wonderful time last week, and we believe even today we'll be enlightened, educated, and empowered. The last time we had our guest on the show, Milkah Kithinji Co, from Mutugi Kithinji and Company Advocates, and I will let you introduce yourself and karibu so much to the show. Tell us, your viewers, maybe someone wants to come for your services as an advocate. Where can they find you?
Thank you very much, Ken, for having me again. I really appreciate that opportunity. We trade by the name Mutugi Kithinji and Company Advocates. We are based at the All African Conference of Churches of Wayaki Way, opposite Safaricom headquarters. Once you get to the compound, we are on the first floor, suite number 8, and you're welcome.
The last time we were talking about issues of contracts on employment. We were talking about notices. We are talking about basic pay, the minimum wage. And there's one thing that we saw being asked, questions that people are asking very much. And one is that when we say 21 leave days or 7 days leave days, are we meaning working days or calendar days? Kama ni 1st of May to 21st of May, or are we saying the working days, which is Monday to Friday or Monday to Saturday, depending on your work? The law provides that you go for leave days on your working days. Because remember, if I work from Monday to Friday, means on Saturday and Sunday I'm off. Even when I'm on leave, I'm supposed to be off. But if you're working from Monday to Saturday, that is what you'll be able to calculate. And that's the reason why when someone goes on leave, they don't just go for 21 days. You realize they have gone maybe for the whole month. And now that is one thing. Another thing that has been asked so much is on house helps. I live with my house help. Do I still need to pay housing allowance for them? Do I still need to provide housing on the issue of minimum wage? And that's what we were saying. Another clarification we'd love to do is on that issue of house help, housing allowance, and minimum wage. The minimum wage, and as we promised, next time we'll be able to have what the latest one as gazetted by the Ministry of Labor, or the Minister of Labor, or the Cabinet Secretary in charge of Labor. It's an average of between 11 to 12,000 on the issue of the minimum wage, and sometimes you need housing allowance. So if you're, and the act is very clear, you either provide housing allowance or you provide accommodation. The fact that someone lives with you maybe in your house means you're providing accommodation, and you can be able to tweak it and argue it even in a court of law, just in case that I was paying her 9,000 or 8,000 because I was providing housing equivalent to 2,000, of which is supposed to be 15%. So you can say maybe 10,000, that's 1,500. So you can say I was giving her 8,500 because 1,500 was housing allowance. Today, we take it a notch higher. Tunaongeza gia kidogo, tunakanyanga mafuta. Tumefanya kazi, tumefika mahali tumechokeshana. Wewe unataka kwenda, ama mimi nataka kukufuta kazi, kwa sababu in this program I'm the boss and you're the employee. Yeah? So what happens the day we reach a point, I want you to go or you want to leave my place of work, you've gotten another place. We call it termination. You may give it whatever name you give it. What happens in that situation, and what's the procedure provided by the law?
Thank you, Ken. Let me start from the employee point of view. Assuming I get greener pastures and I want to leave, so what the law requires me to give notice. You know, if you're on probation, if you're a full-time employee, you're expected to give notice. So if you're on probation, you need to give 1 week notice, 7 days. 7 days, yeah. If you're a full-time employee, you need to give 1 month
notice.
Now, in certain circumstances, you could find the prospective employer.
The greener pasture is very green.
It's very green. Yeah. You cannot wait. They expect you to report immediately at the end, or immediately, or even at the end of the month. So what would happen as an employee? You'd have to pay your employer 1 month notice. So
what you are saying is, if I'm paid 20,000 and I've seen a greener pasture and it's very green for me to wait, I get 20,000, I pay you so that I can leave, then give you the notice.
Yes.
Okay.
So
even for us employers, it's not that bad.
No, it's not that bad. Meaning that the employer will not be forced to pay you the extra 1 month for the notice. So he will retain. So he benefits in that sense. Now, so for the employee, that would be the prudent way to work it out. Now, as an employer, maybe you're tired of this employee. They have misconduct issues. You just want out. So there's a procedure which we'll go through just now. But just as a point out, you cannot terminate the services of your employee based on issues that would, hinge on discrimination. Case in point, if it's a lady, she's expectant. So she's gone on maternity leave and you decide, hey, 3 months, I'll be paying full salary. It's not possible. She's not working. So you decide to terminate her. That is not prudent because then that would cause you to have a lawsuit. What if that employee decides to become a member of a trade union? You cannot discriminate his right of association and then decide because you want to join that union, you can no longer be an employee, I'm terminating your services. What if they also have and they want to run for office? Now they don't want to become a member, but they want to become a representative of that trade union. You cannot terminate their services on that basis. The list is quite long, but those are the 3 main ones that come to mind.
In short, what you are saying is that you cannot terminate my services based on other things apart from what is in my contract.
Yes.
If I come to work at 8, I leave at 5. I perform all my objectives. But during the night, I decide to go campaign for COTU or NAT. You cannot terminate my services because of that.
No, you cannot.
Okay.
So those are just the basics. Now, assuming it is an issue or you want to terminate the services because they're not performing at par, appraisals have been done. Appraisals would mean that there's a system within the organization where there's a manager who reviews the work of the people he's in charge of, and it keeps going level by level, so that then at the end of the day you determine who will remain or who will be laid off. So so we've gone through that process, and this employee maybe performs very well but has a misconduct issue, is harassing others sexually, and there's evidence. Just an example. Now, you as an employer, you don't wake up and say and write a letter, hey, Mr. X or Mrs. Y or Miss Y, you need to leave the office, forthwith.
Pack and go.
Pack and go because of this, these allegations. We don't condone such things. Leave the office by 5 p.m. Should have packed everything. We'll pay you what is yours. Go and never come back. No, that's not the procedure. The procedure is, as you intend to lay off this person, you need first to give them notice.
Notice.
You need to give them notice that say, I am going to be, I need to lay you off. Okay. So let me remove the example of, because that's a misconduct issue. So let's just assume that I'm tired with your work. It's not quality. So I want to lay you off. So I need to give you notice. If you're a member of a trade union, I need to give notice also to the representative of your trade union, send them a letter. If you're not a member of a trade union, I need to give you notice plus the Ministry of Labor. Send them a notice in that sense and say, I want to lay this person off. So I will give you an opportunity to be heard, to come and explain why you think you should be given the job, or if you're going to improve or things. And then now minutes are taken. So you can come with a representative. And on my end, as an employer, I will also have a representative and somebody who will be taking minutes. Once a meeting is done, the minutes are prepared. It may not be the same day, but you'll be called over to read the minutes and confirm if that is a true narration of what transpired in that meeting. If you're agreeable with the same, you sign, you acknowledge. Now, the decision lies with the employment, the management, to decide whether they want to keep you or not.
But yes.
So if they decide not to keep you, then they should put it in writing and say, following our meeting, considering and having weighed the circumstances, it's unfortunate, we will have to lay you off and give you that notice. Right then, now provide a calculation of how they are going to pay your benefits. You know, your leave allowance if you had not gone for leave. If you have worked there for a long time, your severance pay, your NSSF and NHIF, if it's any of it is pending. At that point in time, they're not going to pay you, they're not going to pay it to NSSF. We calculate what is the total and we give you cash, you know, for the number of months that has not been
Especially if they are deducted and they're not remitted.
So what is expected of you as an employee, at the point when you receive that letter, please go to NHIF, get your statement, go to NSSF, get your statement, make sure that what were your obligations have already been met. You know, even iTax, find that your tax, which has already been deducted from your salary, has been remitted. Okay?
Okay, before we go further, there's the issue of notice. I think because most time when people go to court, the biggest challenge to employers is if they did not follow the notice. And I think that's where the courts have really pronounced themselves. And as you said, one of these days we'll be going through 1 or 2 case laws. And one issue you had talked is about the notice. You need first to inform the employee, the reason you want to terminate in that letter. You need to inform them when they need to come for disciplinary, and you need to inform them they have an option of coming with someone of their choice, and if they are members of the trade union, they can come with a representative from the trade union to the hearing.
Yes.
Now, the other thing after that we have finished, there's something you have said. If you have heard me, the employer has done all this, and you have come for the hearing, and I feel like mnanionea because nimejitetea kutosha, but what you are saying is that still the employer has the last call if to retain me or to lay me off. Do I have a recourse after that? Maybe I feel that yes, the procedure was fine, you followed the procedure, you informed everyone, but aiwe hapana, hata kama umeniwekelea. Is there a recourse for an employee?
Yes, there is. So the Act provides a leave. There's a doorway where you can actually file proceedings, or you can file a matter in court under the Employment and Labor Relations Court for unfair termination. Because you see, would be saying, even if the employer would be saying, I gave you notice, I told you, we had a sitting,
you came with a representative and everything,
you signed the minutes. But if you have a genuine case and you feel that really it's unfair termination, then you can bring a case, and that's found under Section 45 of the Employment Act.
Yes.
So it enumerates circumstances where we would be saying there's unfair termination. The most important being discrimination. You know, have you been discriminated against, you know, because you're a lady?
Yeah.
Were you pregnant? Were you disabled in a certain manner? Was it an issue of...
they notice I'm sick with HIV or COVID and they decide to lay me off.
Yes, and they decide, you know, this office, we cannot sacrifice 50 people for one.
Yeah.
And so on that basis, they choose to lay me off.
Yeah.
Okay? Just because they are now in the know. So if we can prove unfair termination, especially either because of how... so I can give you a scenario. There are circumstances where an employee is performing very well.
Yeah.
Then they are promoted, assuming it's a lady.
Yeah.
And then 6 months down the line, you know, they are almost heading a department. The boss realizes they're expectant and says, oh, you know, now because you are expectant, we don't want you to have a lot of work.
Yeah.
So what we're going to do, we are going to relieve you of a lot of work so that you can take it easy on the pregnancy and start giving your roles to somebody else. Okay? And then at the same time, over time, then they start reducing your salary.
My salary, yeah.
Your salary or your allowances. They say, you know, because you're not the one who's going to the meeting. You're not the one we are sending out, so you cannot get this or the other. So they start reducing those perks, you know, over time. And while you're on maternity, instead of giving you full pay, they give you half pay. That is constructive dismissal.
I'm forcing you out of the job.
I'm forcing you
on technicalities.
Yeah, on technicalities. I want you to be frustrated enough
to resign.
So then you see, for me as an employee, it would be very easy. But the employee can also use that very evidence against you as an employer to show how you calculatively sat down. You had every intention to have them leave.
And talking of that, before we move, there's another issue I wanted to remind the viewers, especially if you are in Mdosi. You are the boss here, and you employed me at 50,000. And truly, business is bad. And for this business to survive, you need to give me now 30,000. You don't wake up in the morning and now start telling, wewe, kwanzia leo Ken, 30,000. You need to come, sit me down,
yes.
Let us explain each other. Remember that contract we talked about last week? Let us go write another one. Because if you don't do that and you have a written contract that we have agreed, me and you, to reduce your job because of where we are, this person will work for you for the next 5 years. And when you leave your job, 5 years afterwards, you go bring the first contract, which was 20,000 less, times 1 year is 240, times 5 is almost 1 million and something, yeah. And the court will force you to pay. And that's the reason we are saying it's very important, have everything in writing.
Yeah.
The last one, and maybe the last one is time is not on our side. I don't know what happens when we come to the law and you. I don't know. We'll be praying God now to increase time, or to, like Joshua, the sun to stand still. But now, because it's at night, the moon to stand still. So the other issue is redundancy, especially during COVID. Companies have been coming and they're like, wewe niaje? The job, we cannot support our employees anymore, please go home. Yes, the law allows you to get your employees off on redundancy under Section 40 of the Employment Act, but there's a catch, the procedure.
Yes.
Again, we go back to the notice. You have to notify this employee 1 month. And the catch here, when you do the 1 month, you have to notify them. You have to notify the trade union, if they are part of a trade union. You have to notify, when they come, you have to give a reason why, as if they are advocates. Uwezi toa wakili wa 10 years, watch ya 1 year. Or if it's a driver who has worked for you for 20 years. Or if it's a staff member who has worked with you for 20 years. You start with the least one. Or you start, if it's the 20-year-old, you may come and say there's new technology, maybe computers, that the old ones do not understand. What are we saying? Part of the process is, why me? Out of a company of 10 people, why me, not the other 7? So you have to prove that. And then, remember, if you are firing someone or terminating services, it's not a must to pay service severance pay. But when you are doing redundancy, it's a must. Because you need to give this person a cushion. It's called a landing cushion. For every year of work, 15 days. Those mishahara yake, divide by 2 times the number of years worked. So I think that's another thing that people really need to understand on the issue of redundancy. And what we say, even for employers, before you declare people redundant, consult lawyers. These lawyers are very expensive, but they will save you more money. And even for you as an employee, if you have been declared redundant where you are, please, or maybe you have been terminated, consult a lawyer. It will help you. Maybe you are a millionaire and you don't know about. There's something on discrimination you have talked about. When we talk about discrimination on issues of pregnancy, on the issues, maybe I've gone to court and the court has declared that mimi kama mfanyikazi nilikosewa. How much money are we looking at? Or maybe what's the kind of payments are we looking at?
So, assuming you had, it would have to be a proper contract, not one on probation first and foremost.
So you have to finish the 1 year. The 1 year, you have to work for more than 12 months.
Probation, that probation. You are now an employee.
An employee, yeah.
Meaning the employer has already said that we want to take you on board. We think you're good material, we want to work with you. So you're now an employee, so you're getting benefits from the organization. Benefits that we were saying last week, you're getting a housing allowance, maybe fuel allowance, depending on your caliber. So you're getting those allowance, water, NSSF, NHIF. So you have that. And then when they come now to calculate what is the kind of compensation you can be given, the court would be looking at it from the point of view, what was the length of your contract? Did you have a 3-year term contract? And at month 3 years, 36 months. So at month 10, you were laid off on a discrimination basis.
So you have a balance of 26 months.
26 months.
Wakili, are you saying the court will say 26 months times the amount that I'm supposed to get?
Yes.
If you had a 3-year contract?
Yes. So that then now the court has to, because you see, ideally what the court is saying is that because you were engaged, you are stopped, you are barred from looking for another source of employment. So you are giving all your attention here until your employer...
For the next 3 years.
Yes, for the next 3 years, I want to grow this business. I want to give my best, my all. Then the employer decided to lay you off. So as to give you a cushion to enable you to look for another job, to provide for this new baby in the circumstance of a pregnancy, then we would look at it from that point of view. So we'd be calculating that times your...
So if I had a contract for 1 year, I've worked for 4 months or 7 months, there's a balance of 5 months here.
Yes.
If you chase me illegally, without following procedure, I'll go to court and the court will give me the balance of my contract.
Yes.
And maybe what about if I did not have a contract, but I finished my 1 year, 13 months, because also the law says for you to get a claim against illegal and unfair termination, you have to have finished 1 year.
Yeah.
So guys on probation, usiingie leo kesho unaenda kotini, you have to finish the 1 full year, unless it's a contract. So the one we are talking about, permanent and pensionable.
Yes.
So what happens on that? How will the court calculate? Because on this one, I don't have when I was supposed to end. How does the court calculate?
So in terms of permanent and pensionable?
Yeah.
Okay, so the court will look at, it will still consider the time frame.
Yeah.
And it will also give you a compensation for... so how do I put it? The
12 months, yeah.
The 12 months, assuming it was 1 year, so you get the pay for that 1 year.
For the 1 year.
Then, I have worked for 1 year, but month 2, so I was later. So that is the 11 months, plus severance, because I need to get severance, and any other statutory fee that had not been paid. That had not been paid. But I will also be compensated for the injury caused. The word has slipped out of my mind.
Compensation for 12 months. In fact, most of the courts, what they are saying these days is that some will give you a maximum of 12 months of whatever you are supposed to have paid, but depending on the maximum, sometimes the court may give you just 4 months, may give you 6 months, but that is if you're not on a contract. Ladies and gentlemen, we have just scratched the surface. I was hoping that by today we'll finish, but I think even next week again and next week again, we need to issue on the issues of employment. Wakili, when you were speaking, you talked about discrimination. This discrimination whereby people are laid off on other issues apart from their performance and their work. Things like maybe HIV. In fact, we have a HIV tribunal that deals on those issues. We have maybe issues on pregnancy that you had said. Because some other workers, employers have found this, what they do now. They wait for you to finish maternity, but still come and lay you off after maybe 3, 4, 5 months after maternity. Wakili, maybe I will not be asking you that question, but I want you to be back here again for us to go on case law, because I want to feel, when we talk about this, sometimes our viewers may think ni mambo yetu tunaongelea. But we want to come here with case law, actual cases, because the law allows us to mention cases when they are already done and a judgment has been given, and let us see how much have house helps been given by the courts. Because sometimes house helps and house managers, we have taken them to be like the lowest of the lowest, but they need to understand they're also protected. And that's the vision of One Accord, to empower, educate, and inspire, rebuke, correct, and train different people. So we'll have on that, we'll have on pregnancy, we'll have on HIVs, and many, many, many other things. We join us every Tuesday at 8 p.m. The Law and You. Today we were with Milkah Kithinji, an advocate with Mutugi Kithinji and Company Advocates. Their offices are based just opposite Safaricom at All
African Conference of Churches.
All African Conference of Churches. I've been your host, Kenneth Mbaabu from Kinyua, Mbaabu and Company Advocates, Muthaiga Square. May God bless you.